of Carson City. Call the roll, please.
Chair Borders,
Present.
Vice Chair Cron,
Present.
Commissioner Brooks,
Present.
Commissioner De Christopher, Commissioner Peterson, Commissioner Preston, Commissioner Pizell. A quorum's present.
Thank you very much. Let's see. Mr. Brooks, is it your turn?
It was my turn last.
All right, then in that case, Mr. Crone, Commissioner Crone, will you lead us in a pledge?
You will. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. The public is invited at this time to comment on any topic that relates to a matter over which this public body has supervision, control, jurisdiction, and advisory power, including any such matter that is not specifically included on the agenda as an action item. No action may be taken on the matter raised during this period for public comment. Is there any public comment at this time? Mr. Crone, is that public comment?
Oh, no, sorry. I thought I turned it down. I did. I wonder how that happened.
All right,
It will now be off.
thank you. Having no public comment at this time, we'll move on to item number 5, which is action and approval of the minutes of August 27th, 2025. And before we do that, I'd like to show that Commissioner Preston has arrived. Are there any additions or corrections to the minutes? Good, then, Commissioner De Christopher, will you move to approve the minutes? Thank you. Is there a second? Second by Commissioner Crone. Any further discussion? All in favor say aye.
Aye.
Opposed, no. Motion carries. Item 6A, understand that has been continued. Do I need to address it, or we just move on?
Yeah, if we could maybe get a motion to continue it to date certain October 29th.
Will it be October 29th? Date
Yes, sir.
certain? Okay. Item 6A is LU 2025-0324 for possible and discussion on an application for a special use permit for the modification of ground equipment associated with an existing telecommunications facility to add a diesel generator and associated equipment within the leased area on property zone single-family 5-acre located at 5364 Sierra Highlands Drive, Assessor's Parcel APN 007-051-66. And this, the applicant has asked that we continue this until.
Yeah, Heather Manzo for the record. So I just wanted to note that the application had been deemed incomplete, and we anticipated that it would be complete prior to the meeting. Noticing had gone out for this item, and so that's why it's on the agenda tonight. And yes, the applicant's requesting a continuance to October 29th, date certain.
Will they be ready by then?
Yes, sir.
Okay. So can I have a motion to continue this to the date certain October 29th?
I'm ready to do that. I move to continue LU-2025-0324 to the October 29th, 2025 meeting date certain.
I second.
Is there a second? Commissioner Peterson, second. Any further discussion? All in favor say aye. Opposed, no. All right, motion carries. LU 2025-0310, discussion and possible action regarding an application from Maximilian Newman for a special use permit to allow for a fence to be located within the street side yard setback which exceeds the allowable fence height on property zone single-family 6,000 located at 1102 Armory Lane, Assessor Parcel APN 009-35106. Heather.
Thank you again, Heather Manzo, for the record. So this project was continued from last month's meeting. As you'll recall, the commission had a pretty extensive discussion regarding some of the findings that several members could not make. Most notably was finding number 2 relating to neighborhood compatibility and finding number 3 relating to traffic safety. And then there was one noted finding that couldn't be made for finding number 1, which is about the master plan conformance. So at the meeting, part of the commission's direction to essentially the applicant was to meet with the Public Works and Sheriff's Office staff to address the safety component of the fence that had been constructed. And so with that, this is how the fence looked, right before our August 2025 meeting. The applicant, and we had some visibility issues as we had discussed in August. So what I've provided here is an example northbound on Baker. The applicant did meet with Public Works and the Sheriff's Office to discuss modifications that could be made to the fence to increase visibility. And the applicant did make those modifications within that 2-week time period that the Planning Commission had asked them to make those. So this is the fence as it sits today. They did reduce the site obscuring element above 3 feet tall and added some hog wire or something to that effect, some wire above that, and took off just a little bit of that corner and opened it up as well. And then the other thing that the applicant did is they did carve out the area where the water meter is located. And as you'll see in the recommended conditions, should the Planning Commission move to approve the special use permit, 5B, condition 5B is recommended to be modified to require the applicant to meet the water meter standard detail, and Stephen can address that at the appropriate time. So with that, we summarized kind of the happenings since last month in the memo to the Planning Commission. And the applicant did just circulate some photos for your consideration this evening. And I will turn it over to the Planning Commission, and the applicant is here to speak whenever is appropriate. Thank you.
Any questions? Well, mine was to Stephen, but there are other questions for the staff?
I've got one.
Mr. Crone?
Yeah, was the sheriff happy with the modifications that have been made out there?
Stephen Pote, Development Engineering for the record. Yes, I met with a deputy out on site, and we together marked where the fence needed to be cut back to. And then after the modifications were made, we both went out again. Actually, it was another guy from my staff and the deputy went out and looked at the fence and agreed that it was acceptable.
Now, the reason I ask that is that, excuse me, like Ms. Manzo was talking about, there was a number of discussions about finding number 3, and so that to me is one of those questions that since he raised the issue, is he happy with it? And then the other question that comes into play is from the engineering side, and with those accommodations and those modifications to the fence, is the development engineering happy with the modifications?
Yes, we've both found them to be acceptable.
Thank you.
Okay, Stephen, you want to explain to me the condition about the,
And Heather, do you want to go back to the picture that shows the little cutout? So yeah, this picture shows where the water meter is. Originally, as you can see, it was behind the fence, so we didn't have access to see it. Upon going out and checking the site distance, looked at the water meter. So a couple issues that we noticed are when the fill was added there, it wasn't done correctly with the meter box itself. So there's specific materials that are supposed to be used, and those weren't present, so we'll need to get that fixed. And then the dimensions to the meter, from the meter to the fence also it looks like those still don't meet that standard detail, the minimum distance. So that's what that condition is about, is just making sure that the water division is satisfied with the final installation there.
Okay, but the fill itself, regardless of what we do tonight, that will still have to be fixed, right?
Correct.
And is that the owner's responsibility or the city gonna do that?
That's the owner's responsibility.
Okay. Any other questions for staff? No? Okay. I'm sorry. Commissioner DeChristopher.
Thank you, Chair. Heather, the one question I had is in the photos that were presented by the applicant, there are two that are showing continuous fencing, wood fencing, and that's right up to the sidewalk. There's not an address associated with it. In your estimation, when you look at those photos, is that's still against, those ones are against code, correct? Because they are not following the setback from the sidewalk?
So just for my benefit, we can number them 1 through 4, just for
Okay.
ease. And which ones were you referring to?
Thank you. Hold on. One is theirs. Oh, you know what? It's the photos that were on the second go-round. They were sent to us on computer, so let me see here.
Did you get your hand out?
It might be, but there's other ones that are showing on, if you look at photo 6, I think that's a different section, photo 6, towards the, because there's 2 sections of photos. And if you look towards the back of the packet,
Okay,
and
that one,
it's already marked.
yeah, that one was provided as photo number 4 in the handout that was given by the applicant tonight.
So same one.
Yeah.
That's the same one.
Um,
Okay.
And so I do not know if that is on a corner lot, so there's a couple different things here. Some of these were taken on Colorado Street, where I just kind of did a survey of the area, and I believe that the stuff to the north of Colorado is older development. And it's very possible that the standards were different at the time that those were installed. Also, Colorado as a street is a very different street from Armory and Baker. It's got the bike lanes and the parking on both sides of the street, and then the 3 lanes for travel. So it's a much different street and probably isn't a like-for-like example. And then in terms of other examples, I do know that through the code enforcement appeal process, the applicant had provided some materials there, and staff did say that they would follow up through the code enforcement process on those other properties to determine whether or not there was also a code enforcement issue for those. And if it's not in conformance, then we could pursue code enforcement on those properties as well. So as it is right now, I don't know if number 1, there was a different code in place at the time because the properties are older and the fences are older, or number 2, if there is a code issue that we may not be aware of or is yet to be addressed.
Okay, and thank you for that explanation. To me, that was important to clarify, because that definitely comes into play with the decision of whether or not this SUP gets approved based on other like fences. Thank you.
Any other questions for staff? Okay,
Heather, this question is.
I'm sorry, I dropped my stuff. Commissioner Peterson.
Thank you, Chairman Chuck. Heather, this fence, this structure, did it require a permit? Does it require a permit to put one of these up?
So fences do not require permits, they just are required to comply with code.
And does this fence comply with code?
Are we talking about the subject fence that's
The
before you
subject
this
fence,
evening?
correct. Armory and Baker.
No, so that's why they're before you this evening, is for a special use permit for an alternative to what code would require.
So code enforcement doesn't approve of this?
Oh, so code enforcement doesn't approve or disapprove special use permits?
No, not of
they're-
not just the fence.
there was a code enforcement case that went to the code enforcement appeals or a hearings officer. And that has, at that time, which is part of the original application that was distributed to the commission, it was noted that the fence doesn't comply with code. However, there is a section in our fence code that does allow for a request for a special use permit to not meet that 5-foot setback from property line on that street side.
Or-
So staff is proposing that we look at this SUP to allow this to stay?
The applicant is asking for a special use permit to request permission to leave it the way that it is.
Okay,
Just-
thank you.
Just as a matter of course in the way this thing evolved, this fence was tagged by the city as being non-conforming. They appealed and went to a hearing twice. The hearing officer at that time said you should fix it, or you have the option of a special use permit, which costs money and is not guaranteed. Just because you pay the money doesn't mean you get the special use permit. So it's been through 2 hearings and 1 hearing with us, and now it's back with us for, I guess, the final dispensation of what we're going to do. So is the applicant here? Are they?
Yes, they are.
Okay. Can they come,
I'm Tom Newman. It's my son Max. It's Max's property. Max was unavailable last meeting when we were here.
which one of you is the property owner?
My son.
Okay. On
At our
the,
last meeting, you had requested some modifications to be done to the fence in order to fit visibility and safety issues. You gave us a time limit. Those were all complied with. If we had known about the water meter something different, that could have already been fixed by this time as well.
the conditions of approval that are in this SUP,
I feel like you perhaps have misled us to comply with what is requested from the planning department and then question the fence again. We've tried to do
well, sir, you're not
What
even
you'd
the
like.
property owner. I'd like to talk to the property owner, if that's okay.
very well.
All right, sir, there are 5 conditions of approval for this special use permit. Have you read them and are you agreeable to those? Okay. Push the green button. Tell us who you are.
Yes, sir.
Tell us who you are.
This is Max Newman speaking, property owner.
All right, thank you. And the 5 conditions of approval are acceptable.
Yes, sir.
All right, at the last meeting, I believe where there was some concern about what the fence would look like. And that's why we said we want the applicant and the police department and building and everybody to go out there and figure out what it's gonna have to look like before we approve it. And you went further and go ahead and modified it. And now you're asking, you're back here still looking for your special use permit. Is that correct?
We have already filed the special use permit,
Yeah.
already paid that.
You're looking for us to
To
approve it?
approve it. Yes, sir.
All right. I think the visibility around that corner is still squirrely. And I actually was out there the other day, stopped at that one stop sign that's on the picture, looked to the left, looked to the right. I could see down the street now, so that a car coming down the street from that direction I could see. And I looked to the left and there was no cars coming, and I turned right and there was a giant pickup truck parked right there that I could not see through the fence that I was very close to hitting. It was a gentleman who had stopped there. He had parked there legally and gone across the street to pick up his daughter. And I voted no on this special use permit the last time. I still don't feel very comfortable with it.
Can
And
I, if if you are stepping that hard on the gas around that corner,
I
right
was
there,
not stepping hard on the
you,
gas.
you
or on the
shouldn't
corner.
been moving that fast that you were worried about hitting anybody right there.
It was right, yeah, but it was a startling thing to see him there. That's my point. All right. Are there any other questions for the applicant from staff or from the commission? Okay.
The sheriff was happy with the visibility of it. If
No,
he
it-
wished it
it-
to be set further back,
it-
he would have set it further back.
It technically meets the requirements.
Pardon?
It technically meets the requirements. That's what the report says.
Meets the requirement.
It technically meets the requirements. Okay. All right. The public comment?
On the photos that I just last handed out, the very first photo, we number them 1 through 4. That one is right down Baker and Gills, so a block away from my house, from the subject property.
Okay. Yes? Okay.
Heather, for code enforcement, they don't go out and police these things. Code enforcement is more complaint-driven. Is that correct?
Yes, that's correct. We don't have the staff to proactively seek out code enforcement cases.
So if someone is not in compliance with one thing or another, there's no problem unless someone complains. Is that correct? And if they are found to not be within code, then it becomes a code issue?
That's
Commissioner
correct.
Peterson, if I can just expand on what Heather said. There are times we do proactive enforcement. For example, right now, our code enforcement folks are doing proactive enforcement on signs, temporary signs. They are also doing they're doing enforcement on street side vendors. So there are certain topics which we will, or themes, if you will, if it becomes prevalent, we will do proactive enforcement. Are we currently doing proactive enforcement on signs? The answer is no. We are not currently doing proactive enforcement we are doing it on signs, on fences. So we do some proactive enforcement, and again, it's based on a theme that we may see that we're getting a lot of, so we're like, well, let's go ahead and do proactive. Some members of this commission may recall a few years ago, there was an issue with illegal Connex boxes in backyards, and it was appealed to this commission. The fact that other people have the violation doesn't mean we turn a blind eye to everybody and say, well, until we can do everything, we're doing nothing. That's not the approach. The approach is when somebody alleges a violation, and that's all it is an allegation, we'll investigate it. If it's found, we'll pursue code enforcement. If it's not found, we'll close the case. And so I just didn't want there to be a public perception that there was never proactive, because there are times when it is. Thank you.
Thank you. I appreciate the explanation. Just back to staff, is that if this falls under an issue with code enforcement, I think if we allow certain things or overlook this, how many more SUPs will we see regarding 6-foot fences along a sidewalk because Maximus got to do his? I'm sorry, Maximilian. Maximilian. My mistake, sorry, I apologize. They're both cool names.
Commissioner DeChristopher?
Thank you, Chair. I have, building on what Commissioner Peterson has as a concern, I share that concern. I know a lot of effort has been put into this, including the 2 hearings with code enforcement. And I went back to those notes. And it appears from the notes that the reason the SUP is being asked for is wanting to have the benefit of more safety for your child and wanting to maximize the use of the yard. And as a commissioner, what I think about immediately is, okay, how many SUPs are we going to have because we're granting one that, by the way, didn't come to us initially and ask for it, so there was a complete understanding and you would have had the opportunity to do it right the first time. I know it's been frustrating, but that opportunity existed. And then we go all the way through this, make the accommodation, and now something that we specifically as a city have said, no, this is a public safety issue. We don't want this occurring. How do you then handle the subs coming before you if you've agreed to one based on someone's personal desires, opposed to an infrastructure issue or something of that nature? It's just something I'm personally grappling with in a decision, and if there's anything the city can add to that in helping me understand if my concerns for setting a precedence are valid or not.
Mr. Chair, if I may,
Go ahead.
you will be setting a precedent. That said, I'll remind the commission, and it may only be Commissioner Borders who remembers with me. There was a special use permit issued a number of years ago for a sign to exceed the height limitation. And my recollection is that was over by Betts. And in that case, and Betts is off Curry, just near Greenhouse Garden. Can't think, that's the name of the business, I guess. And what it was you had a residential use adjacent to an industrial use. And the residential use wanted to have a fence that was higher to buffer itself from the industrial use that was next door. So that was approved, and that if that same circumstance were to appear, I would suspect this commission would reach a similar conclusion. So I did want to advise you that this approval has occurred before, and my recollection is that's the only time I believe it's occurred, and that was the situation. And a special use permit does set precedent.
Before this new fence was there was an old fence that came off the back end of the house, and according to our picture, and that fence was conforming, as far as I can tell.
Yes, up until a couple of years ago, before this fence was erected, the fence that was on the site appeared to be compliant.
Okay, so the first motivation was that the slab for the RV, and to fence that in to provide some visual obstruction so that you didn't see an RV sitting in the front yard. So that construction of that fence was the one that made it non-conforming. So, let's see. Commissioner Brooks.
Thank you, Mr. Chair. In listening to Commissioner DeChristopher's concerns, I share them, but I think they are two very separate concerns and should be handled separately. On the one hand, there's the issue of precedent, which Hope was very helpful talking about. But on the other hand, we've had feedback from staff who are present and staff who weren't present but went out to the property, who are the experts we rely on, and they've all said that the property is safe, or for a variable value of safe. They are satisfied with with what's been done. I'm struggling for words, which is unusual for me. I'd like my fellow commissioners to think of two different problem buckets there. Is the property now satisfactorily safe? And separately, is the issue of granting this SUP some sort of precedent that we need to worry about?
Commissioner DeChristopher.
Thank you. I understand what you're saying. What I would add to that is, one, I wasn't the only one who expressed that concern, and I understand from reading the materials that we were actually being asked to focus on compatibility within the neighborhood. How does this conform within the neighborhood? From my perspective, and I would be interested in hearing my fellow commissioners, what their perspectives are, part of making that decision is whether or not the neighborhood has followed code. If I was a neighbor who followed code, did what I was supposed to do, and I have a neighbor who doesn't, that could be an issue. And trust me, this one I've spent more time on, and it's about a fence. And I'm on the fence. Because you have on one side, I am concerned about setting the precedent because it's for reasons that I don't think I could support in the future. Everyone wants to maximize their yard. It should never be maximized if it shortcuts something else. And I would go back to the phrase of technically safe. The sheriff's office has come out and said that's safe. Okay, great. We've had other people who have been down there. They're not experiencing that. But I stand by wanting to hear what my fellow commissioners have to say about the actual question of the neighborhood compatibility. And I'm so sorry, I'm not using the right word here. But we know.
Since it sounds like we're trying to discuss this, I would like to go ahead and make sure that there is no public comment before we do that. Is there any public comment on this issue? Okay, now. You have public comment?
This is
All right, please come forward. You can go sit down.
I've dealt with this type of
Please
issue.
identify yourself,
Oh.
please. Oh, you
my-
got the lights on. Just tell us who
Okay.
you are.
I'm Scott Timoff. I'm a resident here in Carson City.
All right, thank
I've
you.
dealt with this issue over, not here in Carson, but in another jurisdiction in Michigan years ago. And one of the things I believe you're addressing is the issue of precedent. Does it set it? The rule that brings them here today is because somebody left it in the language of the law saying there's an out. You can come here and appeal. And there's a process of it. To say you never can exercise that is ridiculous. So it's been done. It should be done here. He's tried to use his property. It's not if you look at the curve, most streets are square. He has lost his property just because somebody decided to make a wide sweeping curve. Point of views go out to a point at the corner, not at a curve on one thing. So his property is already obstructed or complies with visionary requirements of vehicles on the road. He's trying to use his property, and, fences come and go. Land stays there. He has an RV that he wants to protect, whether it's kids throwing rocks as they walk by or bottles over it at it, or if it's the wind blowing in the wintertime and the snow. He has a concern about his RV. He has to be able to walk along the side of his property and tend to his RV as he chooses. It's his property. A fence like that, it doesn't hamper anybody. Nobody is coming here and complaining about it. You're complaining about it amongst yourselves, just saying it's precedent setting. That's ridiculous. It's a fence. It's a beautiful fence. Fences come, fences go. Homeowners change. That guy could sell his property in a few years because his family is growing and he's going to outgrow it and he wants to move to a bigger property and sell it and take his RV somewhere else. Now, the next guy may say, hey, I don't want a big fence. I want to see my neighbors. I'll cut it off, take it down. He can do whatever he wants. It's his fence. It's his property. So I just say, precedent is that for that reason. It's to set guidances and let people do something with their property. If it becomes the thoroughfare of the community.
Sir, thank you. Okay. Commissioner Preston?
Hey, I'm going to have a little bit of a different thought on this whole thing. Is that, let's bring it back, is to, we say, okay, very seldom do we have anything to do with fences. Just a couple of months ago, on a brand-new subdivision, we had this same thing, where people were building right against the sidewalk when it was actually a planned unit development, and the houses were not supposed to have be next to the sidewalk. They were supposed to have a green space, there was supposed to be a setback, and the developer came in here and asked us to do an SUP, and he paid for the SUPs because these people built their houses. And I look at this and I go, you know, here's the deal, is when I look at this, I'm starting to wonder, and this sounds really bad, because I hate to have, government into everything, but I'm starting to wonder if we should have permits for fences. Because, first of all, the water meter, to me, the water meter should never be obscured, period. And if anybody's ever had a water meter worked on in their property, is that usually you have a bunch of trucks, you have a bunch of other stuff, there's a lot of digging, there's a lot of other things. And the fence is going to be hampering it. I don't even know what kind of a setback or what kind of a, turnaround you're looking at. I look at this and I say, okay, great, we reduced it on the one side, but then the gates are still solid. That just is kind of strange to me. Either it's going to be 3 feet on the front all the way and all the way around to the front of the house so that way there's no obstruction. Again, the majority of fences that I see, you have a setback from the house, and usually they set it back from the house anywhere from 5 to 10 feet so that you don't have an obscuring. This is right off the corner of the house. And I know we're not in here to go ahead and negotiate what they should do, but at this point, it still is right against the sidewalk. It still is obstructing the water meter. And it's still, when I look at the first picture that we have up here on the left, when I look straight across, and I know that I'm not looking across from the neighbors, but if I did this, you see that it is still obstructed right there in the front because of the gates. So, I'm looking at this going, this just doesn't, I feel like we're trying to take a square peg and fit it into a round hole. I don't feel that this is, I feel like we're doing a little bit, but at the same point, not getting to what would be acceptable, so.
Mr. Chair, is public comment still open?
No,
No, it's not.
no.
I am also a homeowner and I've had no say in this meeting yet. So do I get a no? Is it closed for me?
No, I'll take your comment.
Okay. Michaela Morello, on record. Thank you so much. Again, Terry, I appreciate you. You're the one who vouched, and Bob, sad that he's not here today. You guys are the ones who vouched for us, unlike Mr. Cron and Borders, who are on the Just Say No board. I am here to have a conversation, and we're doing everything we can. We're not trying to go against you. It seems to me personally that even committee doesn't even know what the boundaries are, and we're trying to get into the middle of like, what can we do to extend it? As a reference, my son can, his head is right above that fence line. And when we had workers come out, and I guess it's just hearsay, but the sheriffs did say, I don't see a problem with it. If it slows people down, then just plowing out of the stop sign, I say if it works. I don't have that on paper, but I was there when they took the measurements. In addition to that, we are more than willing to cut the gate even more. That was just the starting block. We were told that we could work and take the next board down if needed to. We're not just saying no, we want to work it out with the county and protect my son at the same time. I'm willing to work. Are you willing to work it out? Okay. And that's my 2 cents.
This is not we can't have a discussion with you. You can make you can make a statement, but we're not gonna go into a discussion.
Okay. Well, that's just my 2 cents is I'm willing to work on it, and it just seems like the county doesn't even know what to do either.
Well, it's not the county, it's the city.
City, county.
Right. I didn't say that.
I'm sorry, we're still in the 3 minutes.
Thank you. Sorry. Thank you, Terry.
No, my point was we're not in a discussion with anybody that testifies.
I think that where I'm trying to go with that is that she is the co-applicant and not just regular public comment.
Yep.
I think we need to see if there's any other public comment, and if there's not, close public comment.
Is there any further public comment? Then public comment is closed.
I would now suggest that you go to page 5 of 6 of your report and have your discussion in the framework of the findings of fact.
Thank you. Commissioner Crone, you were next.
Yeah, that's where I was gonna head, where Hope kind of is directing us. One of the things, in order to, at least in my mind, the commission has to determine this on a finding of facts. And there were 3 findings of facts that were called into question last meeting. Finding number 1, finding number 2, and finding number 3. Okay. The reason I asked Mr. Pote earlier about the questions about the traffic issues related site distances, whether the sheriff's department or development engineering was happy with the modifications made by the applicant, was because, in my mind, that determines for me whether or not I think finding 3 has been met. And based on that discussion, I believe finding 3 has been met, which was one of the concerns I had when I was here originally. Another one of the findings was finding number 1. One of the other commissioners, and I don't know who, right off the top of my head, had the concern related to finding number 1. That was not a concern of me at my last meeting. So it boils down for me back to finding 2. And when you talk about neighborhood compatibility, I believe that's a very, very important part of living within a community, living within a neighborhood. And while I'm sure there are examples can be found all over town, you know, and obviously according to what has been provided, there are some that have called into question, you know, the maybe the consistency or inconsistency of the application of this situation. We're here on this particular property dealing with this particular situation. And even after the fence modifications and even after more public testimony, I still believe that fence up against the sidewalk is still not compatible with the character of the neighborhood. And so I don't know where the other commissioners are going to go, but I certainly can't, even after 2 hearings, looking at all the administrative hearing information that we've had, I can't go with 2. And that's, for me, that is a big issue with neighborhood compatibility. It is an older neighborhood. There is a look up and down the streets that I think is very important. And so for me, based on the findings, and that's where I think we need to focus, as Hope indicated, that that's where we need to make our findings of fact. That's where we need to decide, based on these findings of fact, whether or not we can allow this to happen. I'm not, so that's kind of where I'm at. I don't see this having changed much from the meeting that we had previously. I think the applicant has tried to alleviate some of the concerns, but still, based on the findings of fact, I can't get there to agree with finding number 2.
Commissioner DeChristopher.
Thank you, Chair. I can agree with Commissioner Cron on the safety issue if it's been signed off, but I do understand the difference between technical and what actually occurs, but I would be comfortable going with the SO. I cannot make finding 2, having driven through the neighborhood, and I extended the scope of what I would consider a neighborhood. Having grown up here, I know the subdivisions over there well. I could find one example of a similar fence type, but again, it was in compliance in every other way. And I do want to make one comment. I asked a question of the city regarding setting precedent. Because one of the things I do as a commissioner when a SUP comes to us is I go back to look at the history to know that when I make a decision, I'm making a grounded one and one that I can support, not just on how I'm feeling that day. And I did that with this. And the fence SUPs, Commissioner Preston had referred to 2 of them, went back to those. I feel very comfortable with my decision today. I just want the applicant to have some comfort knowing that this is not a personal issue. This is us trying to fulfill our obligation as planning commissioners. Nothing personal at all.
The,
Sometimes cities change.
the,
Changes.
sir, the purpose of a special use permit is to allow for an exception. A special use permit should not be used as a negotiating tool as we work through the problem. They went through 2 episodes with the administrator. They came to us with the permit. We said we didn't think it was acceptable. They went back and tried some more, and they were hearing tonight that they don't think that some of it is acceptable still. And so they ask us, they want to say, now let's try and do another iteration. What else do we do? We're not in the body of let's negotiate. That should have happened a long time ago.
Should have been informed.
Sir, please be quiet. The fallback position is to make the fence compliant with the requirements. If for whatever reason they can't do that, they can ask for a special use permit like they did, and then it's up to us to decide if we're going to approve it or not. But I think the original fence was acceptable. But things have happened since then, and now we've raised the sidewalk 2 CMU blocks. We put in fill. We took out the old fence. We put in a new one. It's 6 feet tall plus 2 feet is 8 feet. There's a whole lot of things, and I can't make number 2. I have a problem with number 3 based on my experience, but I can live without that. But I just don't see that I can make finding number 2. Mr. Peterson, you have anything to say?
Well, I'm in total agreement. And with Chairman DeChristopher, same thing. I think we're all on the same page that we need to stay within the line of legality. Code enforcement stated what it should be. There was kind of not anything that you guys meant to do, that the applicant meant to do, that was ill will, but should have done its homework. They should have done their homework before we got this far. Compliance to me is what's important. Those are written down for a reason. And if we send this one down the road, who knows what's coming behind it. And there are options if they stay within the code that is in place for fences. They don't have to lose their yard. They don't have to go back a 5-foot setback. They can cut it down to 3 feet. It still makes it 5 feet from the sidewalk, and someone would have to be over 5 feet to look in the backyard. So little kids can't look, but it's up to them, whatever they want to do. As long as it's compliant with what code says, that's the direction I would go.
Mr. Brooks?
Thank you.
Thank you, Chair. I don't think we're all in agreement.
Yeah, I'm sorry.
That's all right.
Yeah,
In particular, with condition 2, I am unconvinced that the character and the integrity of the adjacent properties and neighborhoods rides on a 6-foot setback on a single property. That alone is just my opinion. However, we have a report from staff that says that, they believe that the findings of fact can be made. We have reports from our safety experts, our road experts. I don't think this vote, maybe I'm surprised, I don't think this vote is going to go the way I want it to, and that's okay. However, if it doesn't go the way I want based on an overly broad definition of what we believe character should be, I suspect that's something that we as commissioners and this as a body should probably reflect on. Thank you.
Okay. Is there a motion? Terry, I'm sorry. She talked before. You may talk again if you wish.
Mr. Chair, if I may.
Yes.
I just want to clarify for the record what exactly a special use permit is. There are certain uses that are allowed and staff can authorize those. And I think Commissioner Peterson was saying do something that's lawful that the staff can allow. There are other things that might be okay, but they might not be okay. Those are called special conditional uses, and you need a special use permit. The staff doesn't get to decide. You maybe talk to Heather, talk to Stephen, talk to the sheriff, but we don't get to decide. Only the Planning Commission gets to decide, and when they make that decision, they need to look at the findings of fact, which is why I directed them to this page. Who is the Planning Commission? The Planning Commission is a group of 7 residents who represent a cross-section of this community. It is their value system that's applied to these findings. Every single person's value system is legitimate, and a majority of the value system makes the decision. So it is a discretionary review. It's within the purview of the planning commissioners. They look at each of these findings and they make a determination. So I just wanted to outline that. Thank you.
Okay.
Chairman, I'm ready to make a motion.
All right.
I move to deny special use permit LU-2025-03-10 based on the ability not to make the required finding, specifically finding 2, and just can't do it, finding 2. So I'm asking for, motion is for a denial based on finding 2.
Is there a second?
I'll second.
Okay. Any further discussion? All right. All in favor say aye.
Aye.
Opposed? Aye.
Can we do a roll call?
All right, yeah. The motion is to deny the special use permit.
Chair Borders?
Yes? No. Yes. Yes, for 2 and 3.
Okay. Vice Chair Cron?
Yes on denial based on finding 2.
Commissioner DeChristopher?
Yes on motion to deny based on finding 2.
Commissioner Preston? Nay. That's a nay, right?
Nay.
Commissioner Brooks? Commissioner Peterson?
Yes to deny on the second
Motion carries.
proposal.
All right. Item 6C, AB 2025-0271, discussion and possible action regarding a recommendation to the Board of Supervisors concerning an application from U.S. Geomatics to abandon portions of East 6th Street, South Fall Street between the parcels located at 333 East 5th Street, APN 004062-08, and a parcel located at 201 East Sixth Street, APN 004-06501, and abandonment of a 10-foot wide alleyway running north and south bisecting the parcel at 201 East Sixth Street, APN 004-065-01, totaling approximately 28,496 square feet. Are you
Heather Ferris for the
Heather, are
record.
you that?
I'm it.
All right.
Heather Ferris for the record. So the abandonment area is highlighted here in orange. It's a portion of East Sixth Street between South Plaza and South Fall Street, and the portion of South Fall Street between East Seventh and East Sixth Street, as well as the 10-foot alley that runs north and south, bisecting the smaller of the two parcels. The site may look familiar to you. At your July meeting, you approved an SUP for the state for an office building, maintenance building, and parking garage at this location. This abandonment request is a requirement of that SUP. Assuming the abandonment is approved and recorded, the applicant will also complete a lot line deletion, merging the two parcels into one prior to the issuance of the site improvement permit. There are 7 findings that must be made in the affirmative when the Planning Commission is considering a request for an abandonment. The Planning Commission's action is a recommendation to the Board of Supervisors. Staff was able to make the required findings and is recommending the Planning Commission recommend approval of the abandonment subject to the 4 conditions of approval that are included in your staff report. With that, I'm available for questions, and I believe Dirk Goring is here representing the project.
Okay. Heather, you said that this was part of the SUP we approved, that they had to do this.
Correct.
Now, the lot line adjustment is another requirement of that SUP.
That is correct.
But that can't happen until this is done.
That is correct.
Is that the way the steps are working?
Yes,
Okay.
exactly.
All right. Are there any questions for staff? Is the applicant here? Oh, I'm sorry. Go ahead.
No, it's for Stephen. What utilities are existing in those, not only in the, on Fall Street and Sixth Street, but in the little alleyway? Does the city have existing utilities within those streets?
Stephen Pote with Development Engineering for the record. Yes, the city has, I believe, sewer and water, and we're already well underway in terms of the required design to relocate those. And I think that the dry utilities, the communications, also may have some utilities in that area as well as gas.
Okay. So, and this is just when it comes around to abandoning streets, or in this case, an alleyway too, this is something the city normally does when the board gives direction to abandon a street. Then tell me the steps that happen after that's done and how these utilities get relocated and who pays for it.
So in terms of normal process, it's really a case-by-case situation to determine, whether or not we can or need to relocate a utility. It is on the applicant who's doing the project to pay for that relocation. So in this instance, the state is paying to relocate those.
Okay, thank you.
Did you read the conditions of approval?
Yes, sir. And we're in agreement with them.
Okay. Is there anything further you'd like to?
Nope,
Like-
Dirk Goring
like-
for the.
Like to add?
Nope, Dirk Goring for the record. I'm happy to answer any questions.
Okay, how about the pedestrian overpass? You still thinking about that?
I'm not sure that one's on the agenda tonight, but
Good answer. All right, any further questions for the applicant? Public comment? Hearing none? Come back to the commission. This train is starting to leave the station. Pardon? All right. Commissioner DeChristopher.
Yes, Chair, I'd like to make a motion. I move to recommend that the Board of Supervisors approve the abandonment of the roadway easement based on the findings and subject to the conditions of approval contained in the staff report.
Seconded.
Second by Mr. Peterson. Commissioner Peterson?
Sure.
Okay,
Yes.
I'm sorry.
It was me, but that's fine.
That's all right. It was Commissioner Brooks. waxing this year.
Figured I didn't get credit for my last vote.
All right. All right. Any further discussion? All in favor?
I was just going to point out to Commissioner Vern finding 6, which asks if the utility easement should be reserved, continued, or vacated. And 7, which talks about any conditions of approval by the board recommended by Planning Commission. So when you're considering relocation of utilities or preservation or creation of easements, you would utilize those findings.
Okay. Any further discussion? All in favor, say aye. Aye. Opposed, no. Motion carries.
Thank you.
Thank you.
Mr. Chair, if we can just have a, oh, Heather's back. Never mind.
Okay. Item number 6D, discussion and possible action regarding an application from Enterprise Leasing Company West LLC for a special use permit to allow for the establishment of a truck rental use on the property located within the Silver Oak Planned Unit Development and Zoned RCP located at 3246 North Carson Street, APN 007-46206. Heather.
Good evening, Heather Manzo for the record. So the subject tenant space is on the southeast corner of the southernmost shopping center building. It's about 1,500 square feet in size, and the applicant is requesting a truck rental. I wanted to note that our code differentiates vehicle rental from truck rental. And so a large part of the business that Enterprise is going to be operating here is vehicle rental or auto rental, which is not what the special use permit is that's before you this evening. And when we talk about auto rental, we're talking more of a passenger vehicle up to, F-150s and things of that nature. When we speak to truck rental uses, we're talking about like the bigger box trucks like we would see for moving companies and things like that. So these are some examples of the vehicles that Enterprise rents throughout their locations. And they do anticipate that up to 6 of them would be parked at the subject site at one time. So I asked the applicant to send me over a site plan that showed where rental vehicle parking would be located, just to kind of note where everything is going to be situated, and noting that that's not part of the special use permit request. And then also to identify where their truck rental parking would be located. And so this highlights where the tenant space is there on the southeast corner of that building. And just to the east of that are, it's currently 12 parking spaces in between 2 parking lot landscaped islands. That would be converted to 6 parking spaces that are long enough to accommodate the box trucks that they plan on having on site. And so I did want to just provide a picture from North Carson Street. I took this off of Google, so I did not stop in the middle of the intersection there. But I did want to just note that there is a really significant drainage area. It's 150 feet wide. In addition to that, there's landscaping along the Carson Street frontage. And then also some parking lot landscaping on the back end of that. So we've got 175 plus feet between the sidewalk or the right-of-way and where their passenger vehicles would be parked, and then even further back is where their trucks that are requested as part of the special use permit will be parked. So in terms of visibility, I don't see it being a highly visible situation. This is a really underutilized shopping center, as we're all aware, and the use can be accommodated based on the existing infrastructure that's on site. So staff is recommending approval of the request, and the applicant is present if you have any questions for them at the appropriate time.
Okay. Commissioner Brooks?
Thank you, Mr. Chair. Heather, this may be a question for the applicant, but perhaps you know the answer. Is the office space, the transaction space for the property, is it sort of a full service move offering, like can you buy boxes and stuff there, or is it just get a truck and go?
Hi, so my name is Jairo. I'm the enterprise truck rental manager. So no, you simply just pick up a truck and go. people think it's similar to U-Haul, which in some ways it is, but not necessarily. Because we don't, again, you can't just go in there and buy boxes and tapes and all that stuff. Okay. Correct.
Heather, we have approved a special use permit for the most of the rest of that building for a casino that's still active. And my question is, will these parking places affect their parking requirement?
Thank you for the question. So anyone who's driven through there, especially recently, will note that there is a lot of parking in the shopping center. And where their parking is located, I don't see it conflicting in any way with Bodine's once they go in, because Bodine's entrance is going to be on the other side of the building. So the site can accommodate this use plus future uses within the shopping center, including the casino.
Okay. Commissioner Preston?
Okay, this is where I get kind of confused, especially with the RC designation that's in there, is that usually when we have an RC, if, for instance, if we have a Home Depot or a Lowe's, and they actually have things like tough sheds in the parking lot or things like that, there's additional requirement that we have through the building, through your department, that says they can have those outside displays. This, to me, is really no different than an outside display.
I would note that these are vehicles, and we don't define vehicles that are operable in the same way that we do outside storage. So it's a completely different use with a completely different application of exterior parking.
Commissioner Crone?
Yeah, I had, excuse me, I had the privilege to go ahead and drive around the site a little bit. And I actually was impressed with the amount of room between North Carson Street and where these vehicles are going to be lined up. And my assumption is that they would be there, if they're not being rented, they would be there 24 hours a day if they're not being out and rented. So the truck would sit there until rented, correct?
That's correct too. And then typically is my job as well too, is if we have an overflow of vehicles, we do have a base facility where we can take them over to Reno if I see there's too many vehicles on the lot. So very rarely do we have more than 6 vehicles that are going to be there at a time.
Okay, because thank you for that expanded answer, because that's where I was going to go, is what happened if you do end up with a situation where you end up with people wanting to rent more trucks than what you have there. So thank you for that answer. The other thing is just a clarification. As I was reading through your application, there talks about hours of operation, and there seems to be 2 different times in there. I mean, it's one says 8 to 5, the other says 8 to 5:30. I was just curious, which one was it?
As of right now, it's going to be 8 to 5 Monday through Friday, and then Saturdays from 8 to 12, and Sundays closed.
And Sunday's closed. Thank you.
Okay. Since the applicant's here, I'll ask you, the recommended conditions of approval, are they acceptable to you?
So from the amount of times, I'm so sorry, I've just been super, super busy. But from the amount of times I've been able to go look at the location, as far as space-wise, it's fine. They're doing modifications inside the building. Again, space looks fine.
No, the conditions of approval for this,
Oh, okay.
you have to agree to that.
Yes.
Okay. Thank you. Commissioner Peterson?
This is a question for the applicant. It sounds like this will be a satellite store, and the mothership is going to be in Reno?
That's correct. Yeah.
And then maintenance, servicing the vehicles, that'll all occur in Reno?
That's all done through third parties, yeah.
Cool.
Yeah, because there's no space to get it done there, yeah.
I kind of gathered that after you said it was a, secondary
Mhm.
location. Great,
Mhm.
thank you.
Commissioner DeChristopher?
This is just for my information. Does the enterprise facility that is on the south end of town, is that remaining? I believe that's satellite.
That's correct, but that's just the car rental department, so we're just 2 different departments.
Okay,
Mhm.
so
But that
there's-
one's still staying on South Carson.
Okay,
Mhm.
thank you.
Any other questions for the applicant or the staff? Okay, public comment? Please come forward.
Hi, Donna Kuster DeBa. I live on West Nye Lane, and we're right by that location. I have a couple of concerns. First of all, that PUD has no overnight parking in that parking lot. So I have a concern with people going and picking up trucks. Their cars are going to be sitting there. Their motor homes may be sitting there, which we already have an issue with in the parking lot where people park overnight and for long periods of time. So I would like to know how that's going to be addressed. And I mean, I kind of heard that people are going to pick up that truck and then just be done with it within a short period of time. I have found with renting vehicles that doesn't always happen. So I want to make sure that that is somehow going to be policed or set up appropriately where people cannot leave their vehicles there overnight.
Thank you. Heather?
Heather Manzo for the record. So I believe what Donna's speaking to may be some CCNRs or restrictions to the property that the city is not party to. So I can't speak to that one way or another. In terms of the property itself, we have the ability to approve the special use permit for the use. If there's a conflict between the use of the property and whatever's been recorded against the property for restrictions, that would be a civil matter that would take place outside of the city.
Okay, can you come back? When people come and rent a vehicle, do they typically leave their vehicle or do they get a ride?
So with us on the commercial truck rental division, we have a couple options. So typically, before they come and pick up a vehicle before the day of, we make them aware that, because even where we're at the South Carson location, we don't allow customers to park there. So we basically tell them that we can't park at our parking lot and we can either pick you guys up if needed. So up the front, customers are aware that parking is at their discrepancy. Another big thing as well too is on the commercial truck, half of the time these vehicles are used for like long-term projects. So once again, we don't have much vehicles on here. So I guess to answer your question, we make customers aware ahead of time there's really no allowed parking space at our original location, so we'll probably have to do the same thing. Now, it's gonna be kind of hard to dictate, where they leave their stuff, because it's a huge parking space, right? As you mentioned, I've been through that a lot myself. I get what you're saying, right? There's people that just overnight park there, but as far as what I can control, I mean, as long as it's within my law, I know what I can control, but on the other side, it's kind of hard to tell, right?
Well, I don't think we're trying to hire you as the policeman of that lot.
Exactly, yeah.
But it's good to hear that you have that policy in place and I think for the public, just to make sure that you all continue to enforce that would be
Yes.
more than helpful.
Yeah, correct. Because again, it's even a problem too. We don't want to be responsible for their vehicle too, right? Up front, they break in or something, we don't want to be responsible for that.
Okay. All right. Any other public comment? Okay.
So can you clarify, have you had discussions with the property owner or their representative who enforces the CCNRs on how you'll reconcile their lack of overnight parking, or pardon me, their requirement that there be no overnight parking and any traffic that your business may generate? Or have you not had those discussions?
I myself haven't had those discussions, but I can definitely go speak to our development team who's in charge of that. They weren't able to make it in today, but I can redirect that question to you.
I liked hearing that you're willing to police it
Yeah.
up front when they're making a rental agreement.
Mhm.
I just think that that's probably, to the extent that I can make a suggestion, you probably want to have that conversation.
Yes, sir. We'll consider it 100%.
Anything further? All right. Public comment is over. Motion? Let's see. Commissioner Peterson, give it a shot.
Let me go green. Proposed motion, I move to approve the special use permit, case number LU 2025-0327, based on the findings and subject to the conditions of approval contained in the staff report.
Thank you. Is there a second? Second by Commissioner Brooks. Any further discussion? All in favor say aye. 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 Opposed, no. Motion carries. Thank you. All right, item 6E. Here comes the lady. MPA 2025-0344, discussion and possible action regarding a resolution to initiate an amendment to the master plan land use map. Hope.
Thank you, Mr. Chair. On May 1, 2025, the Board of Supervisors adopted the master plan update. When it was approved, the board requested that, one, the staff conduct a community outreach meeting on the land use map, and two, that the Planning Commission consider revisions to the land use map that were derived from those meetings approximately 90 days after the adoption. We did have those community outreach sessions or listening sessions on August 11th at noon, August 12th at 5 p.m., and August 16th at 10 a.m. So that was a weekday day, a weekday evening, and a Saturday. They were all at the library. Approximately 30 residents attended, and members of the Planning Commission attended. I think it was a good conversation, but there was no request to modify the land use map. However, outside those meetings, we did receive a request from the pastor at St. Teresa of Avila Church to modify the land use designation at 3000 Lampa Lane. I have that up on the screen, and you see I've outlined it for you. What happened was they did a lot line adjustment and absorbed some land, so they have a split designation right now, partially industrial and partially public, quasi-public. And so they're requesting that the entirety of the parcel become public, quasi-public, which makes sense to me. We don't really want to have two different designations on one piece of land. It was also pointed out to me that the owners of 1300 South Curry had concerns with their designation. And I have that up on your board too. It's outlined in black on South Curry. It's the west side of South Curry. When I looked into it, the letter was dated March 25th, which was before the master plan adoption, and it addressed zoning as opposed to land use. This area is currently designated as downtown mixed use. This is part of what the commission discussed as the expansion of the downtown mixed use. And so I am not suggesting you include that in your resolution. Certainly you can, but I'm not recommending that. Thirdly, Heather Ferris, our planning manager, came across this one. There's property on Lapeer. It's 4015 Lapeer, and that's privately owned property that was erroneously designated as public, quasi-public. And I have that outlined on your screen as well. It's the purple triangle. So I would suggest that we consider making that high-density residential, which is what that dark brown is that's around it. So what's before you today is a resolution to initiate a master plan amendment. This does not mean you agree with it. It doesn't mean you're voting for it. All it says is you're initiating a process. If you were to pass this resolution to initiate the process, the staff would go through the motions of setting up a public hearing for you. We do all the noticing that we have to do and let the community know that you're considering an amendment to the master plan land use map as has been outlined. And you would then conduct the public hearing, and you would vote however you saw fit based on the findings of fact. Your vote would be a recommendation to the Board of Supervisors. Only the Board of Supervisors can amend the land use map. I'll just remind you, the whole reason we're here today is because the Board of Supervisors had a lot of comments when they went to adopt the master plan on May 1st that things were going too fast and that the community hadn't had a chance to really understand everything. And so what the board said is, okay, well, we're ready to adopt this. But that said, we don't want to make you pay to fix something if we made a mistake with the land use map. We want to give you 90 days. Everyone study your maps. We'll put it on the city's GIS, and we'll have the planning commission look at it in 90 days. So that's why we're here. So I do recommend that you adopt the resolution, but add to it that you'll also initiate a master plan map amendment to redesignate the property at 4015 Lapeer Drive as high-density residential. And I'm happy to answer any questions.
Okay. Commissioner Crone?
Yeah, just some basic process questions. I get the motion that it's just gonna be initiate the amendment. But the other lands that we're talking about in here, the three properties we talked about, why are we voting maybe for one and not the others? Or is this all gonna wait until we go through the process? I'm a little unclear about the process with these three properties. Plus, the other question is, can the public then bring forward more changes?
Okay, I'll take your second question first. Okay, can the public bring forward more changes? Yes, they can. Will they be included at your meeting when you initiate? If you pass the resolution tonight initiating, no. What will get initiated in your resolution tonight is only what's in that resolution. That said, as you know, you annually review the master plan. So if someone brings to our attention that there's a mistake in the master plan, as Heather brought to my attention, the landowner didn't bring that to my attention, Heather Ferris did, based on meetings she had with the landowner. And she's like, well, that shouldn't be public, quasi-public. Then certainly if we see mistakes on the map or things that just don't make sense, at your annual meeting, I will bring those forward, and you'll make a recommendation to the Board of Supervisors, and the Board of Supervisors can direct the staff to go ahead and they're basically initiating, if you will, telling us to go ahead and pursue those changes. I have no authority to initiate a change. You do. So that's the first thing. So yes, we're not locking it down and it can never change. It can change if there's a mistake or something just doesn't seem right. I have talked to you about 3 properties this evening. 2 of them, I believe, should be redesignated. That would be the Lampa Lane property and the Lapeer Drive property. I am not recommending that the South Curry Street property be redesignated, but I wanted to bring it to your attention. You can certainly add it to the resolution if you'd like to, so that you were aware that it was brought to my attention and you have an opportunity to discuss it. Right now, the resolution does not include the Lapeer property because I wasn't aware of it at the time we did the staff report.
And Hope, the Curry property is primarily a zoning issue, not a land use issue. Is that
In the letter that was submitted in March, yes, it focused on zoning, not land use.
okay?
Okay.
All right.
I believe that letter also was because at that time on the land use map, it was named as public quasi.
I think
And that needed to be addressed too.
you're exactly right. I can't speak to the timing, but there was a period of time when that was designated. And in fact, in the 2006 plan, it was designated as public, quasi-public. So we did remove it and acknowledge that it was privately held land.
And it's now part of, from the master plan standpoint, it's now part of mixed use, or downtown.
Correct, the downtown mixed-use designation.
Mm-hmm. Okay. If we pass this resolution tonight with the 2 pieces of property on it, do we hold that, or does it go to the Board of Supervisors?
No, you have the authority to initiate. When you consider initiating a master plan amendment, you have to do so via resolution. That's the instrument you use, as opposed to via a motion or an ordinance. It's a resolution. So because you have that authority, and again, I don't have that authority, you do, you can pass that resolution to initiate it, and then that means it's the same as if I had an applicant initiating it, like a property owner. You, as the Planning Commission, would initiate it. So I now have an application, and I have to start processing my application.
Okay, and if it seems to me that in the November, December timeframe, when we do our annual review, that's when we go forward with all these other changes. So we would take this resolution, which starts that process, and we could add to it any of the others that show up in the next 6 weeks.
Sure, but I have to agendize that you're considering a resolution to initiate an
Okay.
amendment to the master plan. When we look at when we do the master plan annual report, what you'll be looking at things, but you'll be making a recommendation to the Board of Supervisors. And then the Board of Supervisors basically gives us our work plan. So it's a little bit different because I have to make sure I notice it correctly.
Okay. All right. Any further questions? Any public comment? Hearing none. Do we need to amend the motion? Go ahead. Commissioner Preston?
Alrighty. I move to adopt resolution number 2025-PC-R2 to include the additional property of 4015 Lapeer.
Recognizing that you'd be initiating an amendment to redesignate that property to a land use designation of high-density residential.
Thank you.
That's what she said. I heard. All right. Is there
I
a
was just
second?
confirming.
I'll second.
Is there a second?
I'll second.
Commissioner DeChristopher seconds. Any further discussion? All in favor, say aye. Aye. Opposed, no. Motion carries. Staff report.
Okay, director's report. So we give our shout out to Mackenzie, of course, because she does such a great job on our report. So here's the community development report dated September 23rd. As of September 23rd, the valuation of the permits for the month of September was north of $10 million. Total valuation of permits for 2025, 183 million, basically. We've had 11 housing starts so far in September. 4 were single family, 7 were 4 single family attached, 7 single family detached. We actually have some really interesting construction going on right now. We have Brown Street, Dwight's building some more units over there where he was building. Arbor Villas has been picked up by D.R. Horton, so they're building that out. That kind of stalled for a little bit. And then, of course, the more traditional subdivisions with the detached homes, Anderson Ranch, I can't think, it's Toll Brothers just south of Anderson Ranch, and Lampa. They're all going steady. So it's interesting. We talked to a builder who said he has a project in Carson. He has a number of projects, but his project in Carson's selling, whereas his other ones are very slow. So that was positive. So far, we've had 435 housing starts in 2025, which that's a big number for us. You know what you did tonight, so I won't review it with you. Historic Commission's been busy. Heather sits with them, and they had an application to replace doors, lights, install a new sign and a fence, another one to demolish a garage. They discussed a potential zoning text amendment, which would allow for the relocation of a building, but keeping the setbacks that were in place originally. So that's something you might see coming your way. They do not have the authority to initiate a zoning text amendment. So we'd need the property owner who talked to them to pursue that. And, do we have 2 demolition of garages? Wow. Okay, on code enforcement, they're really busy. 63 cases were opened, 109 closed. So that's great to see. Business license, 36 business licenses were issued, and we always like to spotlight something. So Team Whiskey's new retail apparel over on Highway 50 East. Upcoming events, Street Vibrations, it looks like is this weekend. The dog show over at Fuji Park. Then October 11th will be Riff and Rhymes Music Festival at Saltwater Tavern parking lot. October 17th and October 24th, 2 different museums are hosting Trunk or Treat. And then October 30th will be the Bonanza here at Mills Park. And that is Mackenzie's report that I get to give. In terms of future agenda items, you're going to have a busy next month. You have, let's see, a special use permit the one that you just continued on the wireless facility, that will come next month. Over on Savage Street, you have a special use permit to expand a residence, but continuing the existing non-conforming setback. So because it's a continuation of they'll expand the building, but continue that setback, it needs a special use permit. You'll also look at the Kmart again, which they allowed their special use permit to expire. So it has to come back to you, and it continues to be the conversion of retail space to personal storage, retail office, including indoor and outdoor storage of boats and RVs. Over at the Boys and Girls Club, they're asking for a special use permit for 2 metal storage containers. And then over at 5700 Morgan Mill, we have a change of ownership of a marijuana facility, so you'll have 2 special use permits there. One is cultivation, one's production, because marijuana special use permits are not transferable. I also want to announce that on Thursday, October 23rd and Friday, October 24th is the State Planning Conference. This year it will be in Minden at the Carson Valley Inn. If you haven't gotten an email from Mackenzie yet, you will be receiving an email from her inviting you to attend. So just let us know if you'd like to go, and we will sign you up and pay for you to do that. The highlight of the event will be Friday at 10:30 when there's a presentation on the Carson City Master Plan update. So I'll be working with the chair and the vice chair, and if anybody wants to be involved in giving that presentation, would love to do that, and we'll kind of figure out how we do that presentation. Also, actually, on Thursday morning, they have a planning commissioner roundtable. That could be really interesting. I think that's at 10:30 if I remember right. I don't know. But if you didn't see that yet, Mackenzie is sending that out, and we'd love to have you guys come. I'm going, Heather's going, Mackenzie's going, so Carson City will be well represented. And that's my report.
Okay. I would like to remind the commission that in November and December, we are going to meet earlier in the month. Last time we sent that out, you probably didn't write it on your calendar, and now your calendar is getting full. I just recommend that everybody check and make sure that they're available for November and December.
We can have Mackenzie send a reminder out tomorrow.
They're about a week early for both.
Instead of it being the last Wednesday, it's the second to last Wednesday.
Oh, yeah, you and I talked, we were gonna miss the November one.
I think November, I'm gone, but.
I suspect I will miss that November.
Okay. Well, that's the other reason, because if you're not gonna be here, we need to make sure that we have enough people for a quorum. And, yeah. So. Okay. Well, I just don't want us to show up and have 3 people here. Okay. Commissioner Preston?
Okay, I have a question, Hope. Just because I've seen some things happen here sometimes, I just want some clarification on this. Regarding the fact on a fence, we're going to kind of bring this back, on a fence that you're not required to have a permit, however, you need to comply by the Carson City Municipal Code and the Carson City Development Standards. Is the Municipal Code and the Development Standards available on the Carson.org website?
The fence regulations are there. You go to government, then you go over to the left side to municipal code, and the entire municipal code is there.
Okay, and that
It's in
includes the
Title
development
18.
standards?
Yes, it's the Title 18 appendix.
Okay. And I think that's kind of funny because sometimes people aren't aware that there are requirements and not a lot of people crack that baby open. Because we've seen you with your little roly things. So my question is there any way that we could get it out that before, kind of like before you dig 811, put something there before you do something?
Very good idea. And we we have done PSA, public advisory statements, I guess they're called. And we've done it, for example, when there's going to be snow. Oh, reminder, when there's snow, you have to shovel the sidewalk in front of your house. And from a code enforcement perspective, we do it for RVs, for example, when it starts to become spring. Reminder, you can't park the RV on your property for more than 72 hours. So we can certainly look at having some type of announcement about fencing. Again, it's a one-shot deal, so we're not capturing everyone, but it's maybe like mattresses. Every time you need a mattress, there's a sale, right? And so we'll see.
I think that the thing that comes up with that is, maybe even just remind people, check to see if you have to get a permit for something, because some things seem to be really easy. I mean, where I'm looking at this going, okay, now we added, 2 blocks, and then we added fill, and we added this, and we added that, which in some municipalities, if you added fill, you're done, so that's why I want to definitely make sure that people are aware of that, because that way we don't have confusion.
No,
So-
that point's well taken. Thank you.
Well, Terry, I agree. Because, I mean, if someone were to call, like, say, do I need a permit for a fence? And they're going to tell them, no, you don't. So they're going to go, oh, free for all. Cool, let's go get lumber. Let's go to Lowe's. Let's get started.
Which brings up a really good point. Where you go for your fencing supplies on the East Coast, and it's one of the reasons I wasn't even thinking about it at the last meeting in terms of fencing requirements. They were posted at the big box stores or lumber supply companies.
I feel like we're having, and
Too
I don't
much,
want to pick
okay.
on you, I feel like we're having too
We're-
much
we're
of an
trying to-
extensive conversation. But your point's well taken, and we do need to educate the community. Just because something doesn't need a permit doesn't mean there aren't regulations in
Right.
terms of how tall it can be, where it can be located. So I understand.
Okay.
And
Anything
if
else?
you have ideas, you can come talk to me or Heather, or the other Heather. She's
Commissioner
still here
DeChristopher.
after.
Yeah, Commissioner Brooks had brought something up tonight, and I agree with you that after the SUP conversation on the fence, it really is a bigger discussion. And I'm kind of curious to see if it comes up at the Planning Commission Roundtable at the APA. But the question of what people's rights are to their property. I know I kind of tried to have that conversation when we had a joint session with the supervisors, and I like to tease Stacy. He laughed me out on that one. He goes, "You really want to take that one on?" I think you do take that one on, at least to the extent that you have a civil conversation as commissioners and possibly with the supervisors. Because when you go, and I'll just speak from what I've seen. When I talk to people about the master plan, predictability was very important to them in zoning and building code. And I believe it was Rob Pizell, unfair of me to say that when he's not here, but he had made a comment during one of our planning commission meetings that, okay, when we look at Title 18, what happens when people are allowed to do certain things to their property that are very different than when anyone in that area had thought to be true? And this fence is not a perfect example of that, but similar.
So I think we can certainly, we can have some type of training, and if you go to the conference, that would be great. We have our attorney sits here with us to make sure you guys don't stray to a place you're not supposed to be, and you have not strayed to a place that you're not supposed to be. Okay.
The question for the attorney would be, the question for the attorney would be, if there's a municipal code, if there is a development standard, but if there are also recorded CC&Rs and deed restrictions, which one would prevail?
Oh,
And
actually,
Michaela-
the code speaks to that. Title 18 does speak to that, and Title 18 does say that the municipal code does not trump CC&Rs. That said, the city is not the enforcement agent on CC&Rs.